Good morning, distinguished guests, supporters, ALSA committee members, ladies and gentlemen. Welcome to the ALSA and Australian Red Cross International Humanitarian Law Moot Competition. Over the last 5 days, competitors have displayed outstanding mooting with teams representing their universities all across Australia. Today, we are fortunate to have on our judging panel the Honourable Justice Leslie Taylor, Yvette Zegenhagen and Michelle Lash. The Honourable Justice Leslie Taylor was appointed to the Supreme Court of Victoria in July 2018. She had previously practiced as a lawyer for 25 years, including 20 years as a barrister at the Victorian Bar, where she was appointed Queen's Counsel in 2011. As counsel, Justice Taylor primarily undertook criminal cases, both prosecuting and defending in areas ranging from terrorism to corporate crime to murder. Justice Taylor has also worked in various international bodies, including under the auspices of the United Nations and the High Commissioner for Human Rights. In this regard, in 2004 and 2005, Justice Taylor was Senior Trial Counsel at the Office of the Prosecutor in Sierra Leone. In 2006, she was Senior Counsel assisting the Independent Commission of Inquiry into Timor-Leste, and in 2011, she was Senior Advisor to the Special Independent Commission of Inquiry into Kyrgyzstan. Justice Taylor also regularly teaches internationally, having instructed in advocacy in Uganda in both 2015 and 2017, and in Cambodia in 2016. Yvette is the National Manager of the IHL program at Australian Red Cross, having joined the program in 2011. Prior to joining Australian Red Cross, Yvette worked as an adjunct teaching fellow at Bond University Law Faculty and as a commercial litigation lawyer in Melbourne. Yvette is currently the chair of the Asia Pacific National Society Legal Advisors Network and has also held the position of Common Law Legal Advisor within the Legal Advisory Service at the International Committee of the Red Cross, ICRC, in Geneva. Yvette is admitted to practice as a legal practitioner to the Supreme Court of Victoria and High Court of Australia. Dr. Michelle Lash is a visiting fellow at the Melbourne Law School and teaches international criminal law at the London School of Economics Summer School. She was recently a human rights investigator on the UN Commission of Inquiry into the Gaza protests. Michelle has a PhD on targeted killing and international law from the University of Melbourne and was a postdoctoral fellow at the Hebrew University of Jerusalem. She has worked at the Israeli human rights organisation B'Tselem as the principal researcher for the Turkey Commission on investigating alleged violations of the law of armed conflict, and as an assistant to Israel's Deputy Attorney General for International Law, and as a human rights officer for the former UN Special Rapporteur on the occupied Palestinian territory, Richard Falk. Thank you for coming to watch this final. It has been an absolute privilege to be involved in facilitating this esteemed competition. Please enjoy and best of luck to our competitors.
seated. Would the parties announce their appearance, please?
May it please the court. My name is Rourke, R-O-U-R-K-E, initial R, and I appear here with my learned junior, Shields, S-H-I-E-L-D-S, initial M, for the prosecution in this matter.
Thanks, Mr. Rourke.
Your Excellencies, my name is Elmes, spelt E-L-M-E-S, and I am here with my learned junior co-counsel, Chalmers, spelt C-H-A-L-M-E-R-S, and we appear for the defence.
Thank you, Ms. Elmes. Mr. Rourke.
Your Honours, before I commence, could we please hand up some bundles of authorities to the bench?
Yes.
May it please the court. Your Honours, the purpose of today's hearing is to confirm the charges against the two defendants, Dr. Lee Tower and Brigadier Zealous. Your Honours, at this stage of the proceedings, the prosecution need not prove the guilt of the defendants beyond a reasonable doubt. We must only establish substantial grounds to believe that the defendants committed the crimes alleged. I will be addressing the charge against Dr. Tower, namely that on the basis of individual responsibility for ordering the commission of a crime, Dr. Tower is charged with directing an attack against personnel, installations, materials, units or vehicles involved in a humanitarian assistance mission. On this point, Your Honours, I will be making three overarching submissions. Firstly, that this court has jurisdiction to hear the matter. Secondly, that the substantive elements of the war crime under Article 8(2)(b)(3) of the Rome Statute can be established. And third and finally, that Dr. Lee Tower can be held individually responsible under Article 25(3)(b) of the Rome Statute. Turning first to the issue of jurisdiction. Your Honour, it is our submission that this court has jurisdiction to hear this matter in accordance with the criteria set out in Article 2.1 of the Geneva Conventions, namely that this court may hear matters in relation to circumstances where there has been a state of declared war or otherwise an international armed conflict. And we submit that both of these criteria were met as at the time the virus was deployed on the 8th of December 2017, and we will make each of those submissions in the alternative. Turning first to the issue of declared war. Your Honour, we submit that in accordance with the views set out by the ICRC in their 2016 commentary to the Geneva Conventions, there is no particular form of words required for a declaration of war, as long as it satisfies two criteria. Your Honour, firstly, that the declaration be formal by a constitutionally competent authority of the state, and secondly, that there be an intention in the declaration to commit the state to a declared state of war. Your Honour, it is our submission...
How much weight should the court give to the ICRC commentaries?
Your Honour, this court is able to refer to the commentaries as per Article 21(1)(b) of the Rome Statute, which says that applicable treaty may be applied in interpreting the elements of the crimes. We would submit that the ICRC commentary is an authoritative source of international law under the ICJ statute, in particular Article 38(1)(d), which states that the works of highly qualified publicists may be authoritative, and it's our submission that the ICRC is such a highly qualified publicist, given that it is the authoritative body on IHL, and indeed it's the repository of the Geneva Conventions themselves.
And does their interpretation reflect either jurisprudence or state practice, or are the ICRC alone in this interpretation?
Your Honour, in the commentary they discuss state practice and various other case law and international law around the world in coming to their interpretation. So, Your Honour, we allege that the state of declared war between the Federation and New Utopia commenced in October 2018, namely paragraph 7 of the facts, where Dr. Tower in a public speech, declared that New Utopia has proven to be an enemy to progress and an enemy to the Federation, and let us unite against a common enemy. Your Honour, we submit that this is sufficient to meet the first criteria of formality, and as to the second criteria of intention, it's our submission that this speech alone gives rise to the relevant hostilities sufficient to commit the Federation to a state of war.
What is it about this speech that you say satisfies the element of formality?
Your Honour, so the facts at paragraph 7 suggest that Dr. Tower gave this speech in his formal capacity as President of the Federation, as opposed to other statements throughout the facts where he merely gave a private comment about war. We say that this speech, it was described as a sweeping speech, suggesting that it was in front of an audience, is sufficient to satisfy this criterion.
Is saying we should unite against a common enemy sufficient to indicate a declaration of war?
Your Honour, we do note that the word war is not used in this particular instance. However, we submit that the relevant intention in this particular speech can be discerned from the context of which it occurred. Namely, it was the culmination of hostilities between the Federation and New Utopia throughout 2018, from the incidents of terrorism to the public accusations by Dr. Tower against New Utopia, and finally, this speech was delivered after the information campaign against New Utopia. So it's our submission that this meets the criteria. In the event that Your Honours is not satisfied there was a state of declared war, we would nonetheless submit that the deployment of the virus on the 8th of December was sufficient to trigger an international armed conflict. Your Honours, in accordance with the case of Tadic in the ICTY, there are two criteria which must be satisfied to give rise to an international armed conflict, namely a resort to armed force between states. Your Honour, turning to the first limb of that test, namely the resort to armed force, it is our submission that the virus in this case is sufficient to amount to a resort to armed force in light of the fact that it produced similar kinetic consequences to an ordinary military attack, namely the death of 125 civilians. So, Your Honour...
Does that mean that your reasoning is that it's the result of an action by which it can be defined?
So, Your Honour, that is our submission. Our submission is that in accordance with the purpose of IHL, which is to protect civilians and other parties in the duration of conflict, we would submit that the resort to armed force should not be defined by the means of the attack, which need not be physical. We submit that it's the actual consequences of the attack of the actual resort to armed force that should be used to determine this. And this is in accordance with the views of the ICRC in their 2016 commentary, where they state it's uncontroversial that any sort of attack or operation that gives rise to deaths would be likely to amount to a resort to armed force.
And do those consequences need to be intended before the attack's taken out?
Your Honour, we would submit that the intention is not so much relevant in this case. Indeed, the reason why the concept of an international armed conflict, as well as a declaration of war, was introduced into the Geneva Conventions was to remove any ideas of subjectivity from the equation. So we submit that if it does result in those consequences, therefore IHL should apply.
You also mentioned that there doesn't need to be any kinetic force for an attack. What source would you cite for that?
Your Honour, we would rely on the decision in Tadic in that case. In that case, they held that even chemical or biological weapons, which do not have the kinetic force per se, but nonetheless result in death or adverse consequences, are sufficient to amount to armed force. So, Your Honour, we turn now to our second overall substantive submission. Sorry, Your Honour.
Can I just clarify, is the basis for jurisdiction either the declaration of war or resort to force, which are both indications of an international armed conflict, and therefore the Geneva Conventions apply on the basis of Common Article 2 of all 4 Geneva Conventions?
Your Honour, it's our submission that Article 2.1 of the Geneva Conventions provides that their applicability is either in cases of declared war or in any other armed conflicts between states. We say that either there was a state of declared war or in the alternative there was nonetheless an armed conflict between states. And Your Honour, to conclude our submission on this point, I will just address the matter that the second limb of the test in Tadic, namely that there was a resort to armed force that was between the Federation and New Utopia. Your Honours, we accept the difficulties inherent in identifying the perpetrator of a cyber operation such as the virus. Your Honour, in fact, we recognise the submissions of our learned friends at paragraph 2 of their written submissions, wherein they state that the forensic evidence which we have before us, namely the IP addresses which link the virus's deployment to an overseas federation's intelligence agency, may not be given much weight in this case because of the possibility of spoofing or forging by a third-party hacker. Your Honour, we accept the difficulty. However, it is our submission that the evidence viewed as a whole, nonetheless, is sufficient to establish the prosecution's burden in this case. Now, the burden has been described in the case of Labanga as being able to offer a concrete and tangible proof demonstrating a clear line of reasoning. We are not required to discharge all other possible hypotheses. And it's our submission that these IP addresses, in combination to the other evidence which we have linking the possibility of the virus's deployment to the Federation, namely the expert reports stating that it must have been state-sponsored, in addition to the video evidence of Dr. Tower referring to a particular line of code in a Federation government conference, we say that this is sufficient to at least provide a clear line of reasoning to establish substantial grounds to believe that it can be attributed to the Federation. And that attribution then is in accordance with Article 4 of the ILC's draft articles on internationally wrongful states, which states that any act of a state body can be attributed to the country itself. So, Your Honour, turning now to the second overall substantive submission, namely that the war crime elements can be satisfied. Now, Your Honours, these elements can be found at tab 3 of our bundle of authorities. If I could take you there now. Your Honour, we'll be referring to these elements throughout this submission. And Your Honours, so the first element which the prosecution will establish is that the Overseas Federation Agency of the Federation directed an attack by deploying the virus. Your Honours, we note that the term attack is not defined in the Rome Statute. However, in accordance with Article 21(1)b, we may look at other applicable treaties, which we say in this case the first additional protocol, in particular Article 49(1), is relevant. In that particular article, attacks is defined as any resort to violence, an act of violence against the adversary. Now, Your Honour, we would submit that interpreting this term violence in the article in accordance with the purposive approach to treaty interpretation under Article 31(1) of the Vienna Convention, we would submit that an appropriate construction of what violence means is violent consequences rather than violent means. Your Honours, we would submit that the relevant violent consequences that could characterise and act as an attack for the purpose of this article is if they resulted in death, injury, or destruction of property, Your Honours. And it's our submission that for the same reasons as to why the virus was a resort to armed force for the purposes of jurisdiction, that also is the sufficient violent consequences for the purposes of establishing an attack.
What then would the argument be if a virus was released but it didn't have the consequences? Would that still be an attack?
Your Honour, we would have to look to the code of the virus and the way in which it operated. We note that in Michael Schmidt's Talon manual, wherein he interprets Article 49 in the context of cyber operations, he notes that any attack that will be reasonably likely to result in death to citizens, even if it does not actually occur, would amount to an attack. And we would submit that would be the case. Your Honour, we would submit that it makes sense in light of ordinary military operations. If an enemy fires at another enemy and doesn't hit them, they have nonetheless delivered an attack. So we would submit...
But the difference there is that the firing of a gun is inherently violent.
Your Honour,
the releasing of a virus is not.
We would submit that the very nature of this virus and the way in which it introduced misinformation indiscriminately into a database which contained medical data, we submit that that in itself is inherently violent because it has the possibility of endangering any of those people in the hospitals who rely upon that data. So even if there weren't deaths as a result of the misinformation, we say that the very nature of how this attack carried out is sufficient. Your Honour, turning to the second substantive element, namely that the object of the attack was personnel, installations, materials, units or vehicles in a humanitarian assistance mission. Now, Your Honour, in accordance with the case of Bemba in this court on the confirmation of charges, the prosecution must establish that these objects were the primary object of the attack as opposed to an incidental object. Before we turn to our submission as to why it was the primary object, we must first establish that it actually falls within the list of prescribed targets. It's our submission that medical data in this case, which was altered by the virus, falls within the scope of the definition of units in that list. Your Honour, turning to the meaning of units in Article 8E of the first protocol, this includes hospitals. We submit that a proposed interpretation of the term units, medical units, must include any essential data or equipment associated with that hospital unit, such that if the medical data is affected, therefore the hospital unit has been affected.
How do you explain that it's within the intended purpose of Article 8, which is about medical establishments and units that are used for military purposes? For example, when a hospital is taken over by combatants and things like that. So can you explain a bit more how you see this specific example in keeping with the intention of Article 8?
Your Honour, we would submit that the main reason why we can draw this interpretation is in light of the duty to respect medical units, which is contained in the Geneva Conventions. If enemies are allowed to attack data from a medical unit or essential information, and it was not within the definition of a unit, therefore the protection afforded to that medical unit would be compromised, and the attacker could deliver adverse consequences on the unit without actually meeting the definition of respecting that unit. Your Honour, turning now to whether it was the primary object of the attack. Now, Your Honour, the appeals chamber of this court in Galich noted various factors which we can take into account in determining the primacy of the object, and two of those were the means and methods used of the attack and the extent to which the attacking force has attempted to comply with the requirement to take precautions in attacks. The court in that case then concluded that in some cases an indiscriminate attack may qualify as being tantamount to directing an attack against civilian objects in the circumstances of the case. And we would submit that in the present case, the Agent Doom virus can be characterised as an indiscriminate attack under the meaning of Article 52.4a of the first protocol, because it wasn't directed at a specific military objective. Your Honour, we can infer its indiscriminacy from the fact that it equally affected medical and military data in the NUDF IT system. There seems to be no attempts in the code for it to actually comply separately and attack the data in unique ways. And furthermore, we say that in light of the fact that in paragraph 2 of the facts, it states that it was common knowledge that the New Utopia was trialling electronic systems for their medical services, we would submit that the failure of the Federation to inquire and get intelligence into these reports, however unofficial they were, is a failure to take all reasonable precautions to distinguish before an attack is carried out.
So would the primary object of the attack have been military or civilian?
Your Honour, we would submit that where there is an indiscriminate attack like this, it can be inferred that although the attack seems to be directed at a military object, it is tantamount, due to its indiscriminacy, to directing the attack against the medical civilian data.
And would you agree that that object was a dual object because it had both military and civilian aspects to it?
Your Honour, we would characterise that the actual medical and military data as separate objects. We would not characterise the system as one overall object. It merely contains different data within it.
So there were two separate attacks with two primary objects?
Your Honour, that is our submission, and it can be inferred from the indiscriminacy of the attack.
But would you argue that the first attack was discriminate in that it was only targeting a military objective?
Your Honour, we would submit that this attack was carried out without a clear military objective in mind. Although it ended up affecting both the military and the medical data, we would submit that the failure to take precautions previously suggests that there was no clear military objective. It was just directed at this overall IT system with the hopes that it would hit something, namely either the medical data or the military data.
So is your argument that the attack in and of itself was indiscriminate, which is also a violation of international humanitarian law, but doesn't meet the specific charge that we're currently arguing?
Yes, Your Honour, we rely on the words in Galich which state that an indiscriminate attack can be tantamount to directing an attack against civilian objects. Your Honour, I note that I only have a minute remaining of my time. May I please request a 2-minute extension to get to the end of my submissions and answer any other questions?
Yes.
Thank you, Your Honours. So, turning now to the next element of the crime, namely that there was the intention to target that attack, we would submit that the relevant intention of the members of the intelligence agency, the direct intention, can be inferred from the deployment of a virus that was indiscriminate in nature. And so it follows from our previous submission that the relevant direct intention was present. Your Honours, turning to the fourth element of the crime, that the data has to be entitled to protection as civilian objects, we would submit that the medical data, falling within the scope of a unit for the purposes of this crime, is entitled to protection under Article 21 of the Geneva Conventions, namely that they are entitled to protection which would not cease until it was used to commit acts adverse to the enemy. We know that our learned friends have made submissions that intermingling of data was sufficient to meet that criteria. However, in that same article, a warning must be given to the hospital that an attack is going to occur, and this did not occur in the present case. Therefore, the protection remained at all times.
Would you consider that the warning should be the same to the hospital for a physical attack and for an attack on a virus? Attack on a system?
Your Honour, we submit that on a plain reading of those terms, it should be. Your Honour, we note that elements 5 to 7 of the crime are fairly uncontentious and have been mostly conceded by our friends, so we propose to rely on our written submissions for the purposes of their establishment and spend the remainder of the time on the issue of ordering. On ordering, there are 3 elements, Your Honours. There must be a superior-subordinate relationship, there must be the transmission of an order, and there must be the relevant mental intention of recklessness. Your Honour, we submit that there was a superior-subordinate relationship as Dr. Tao was president of the Federation. He had authority over the government bodies that deployed the virus. We submit that the circumstantial evidence in the present case leads to the inference that he transmitted an order. He had the motive to direct the order given his hostilities against New Utopia and his references to the virus in the Security Conference. So we submit that an inference can be drawn. Finally, we submit that the standard of recklessness in accordance with the case of Blasic is sufficient to, given the indiscriminacy of the virus and Dr. Tao's knowledge of its nature, we submit that he must have known that deployment, giving an order, would lead to the commission, with a substantial likelihood of the commission of a crime. Your Honours, we submit, therefore, that Dr. Lee Tower ought to be committed to trial. Your Honours, may it please the Court, those are my submissions.
Thank you very much, Mr. Rourke. Mr. Shields.
May it please the Court. I'll be making the submission for the prosecution that Brigadier Elmes is responsible for the war crime of employing expanding bullets in an armed conflict, pursuant to Article 8(2)(e)(15) of the Rome Statute, and so he should be committed to trial. These submissions will be delivered in 3 parts. First, we submit that this chamber has the jurisdiction to hear the matter, as the incident occurred in the context of an armed conflict. Second, we submit that the Summer Sons Brigade, commanded by Brigadier Elmes, employed expanding bullets in violation of the Rome Statute. And third, we submit that Brigadier Elmes should be held criminally responsible pursuant to Article 28A of the statute for his command responsibility. Turning now to my first submission, found in paragraph 28 of our written submissions. This chamber has jurisdiction as the relevant conduct took place in the context of an armed conflict. We submit that there was a non-international armed conflict, which will be referred to as a NIAC, between the Federation and Rio Lisdale at the relevant time, causing the conduct to be criminalised under Article 8(2)(e)(15). The case of Prosecutor and Lamage, decided in the ICTY trial chamber in 2005, set out at paragraph 84 of that judgment that for there to be a NIAC, there must be both, first, a sufficiently intense conflict, and second, that the parties to that conflict be sufficiently organised. In regards to the present facts, we submit that the conflict was sufficiently intense, both due to the level and duration of the violence. This submission is especially supported by the Federation's need to escalate from police to military involvement against the insurgents. To begin, the Federation had been suffering from insurgent bombings and shootings since early 2018, as evidenced at paragraph 6 of the facts. This conflict escalated in Isdale specifically in November, as evidenced at paragraph 10, with rare earth mining operations being particularly targeted. Although Real Isdale itself did not officially surface until the 2nd of December, on that day they released a large number of propaganda and training videos at paragraph 13, revealing their military-grade equipment and military-style training. Finally, on the 23rd of December, at paragraph 25 of the facts, they fought a battle against the Federation, which involved thousands of personnel, with hundreds dead as a result. It has been put against us in the memo provided by our learned friends at jurisdiction paragraph 5 that the violence was not protracted, but rather isolated and sporadic. Respectfully, that is not the correct conclusion for this chamber to draw. The present conflict can be contrasted against the conflict in the matter of Abella and Argentina, decided in 1998 in the Inter-American Court, in which that court determined that a 30-hour conflict involving only 19 dead people was sufficiently intense to be determined a NIAC. Now, we do not submit that this chamber must accept such a low bar to the finding of a NIAC, but merely reference this case as evidence that such a low bar may be set.
Was there anything in particular about that conflict other than its duration and the number of dead that contributed to the meaning of intensity?
Yes, Your Honour. So the court in that case considered the nature of the violence in that there were military-style forces using military equipment against each other, which is relevant in the present case, as well as the organisation of those parties, which again is also relevant in the present case. The conflict in this present case, additionally, Your Honours, was far more intense than that conflict in Abella, with thousands involved in the conflict, hundreds dead, and violence lasting for over a month, from the 24th of November to the 28th of December, where a UN-brokered ceasefire was in place. Therefore, we submit that the violence in the present case was sufficiently intense to be considered a non-international armed conflict. Turning now to the organisation criterion, we submit that Real Isdale was sufficiently organised to be considered a party to the conflict. In the case of Bemba, decided in the trial chamber of the ICC in 2016, at paragraph 134 of that judgment, the chamber provides a non-exhaustive list of factors potentially relevant to determining organisation. This list includes the force's command structure and rules, the extent to which military equipment, including firearms, are available, the force's ability to plan military operations and put them into effect, and the extent and intensity of any military involvement. The trial chamber further noted at paragraph 134 of that judgment that none of these factors are individually determinative, but they must be considered as a whole. Therefore, considering the totality of the evidence in the present case, in light of this list of factors, we submit that Real Isdale was sufficiently organised, both as a result of the availability of their military equipment and training, as evidenced in the videos at paragraph 13 of the facts, and their ability to fight against a trained military force in the battle of paragraph 25.
And how do you explain where New Utopia fits into this NIAC in light of the presence of its armed forces on the territory and also the statement by Leader A on the 25th of December?
Your Honour, we made no submissions as to New Utopia being a part of this NIAC, although we have the potential to press an internationalised international armed conflict following the determination of a non-international armed conflict. There must first be in place a non-international armed conflict, as by the Lubanga decision at paragraph 209. And
just to clarify, you said an internationalised international armed conflict.
So an internationalised conflict, which is an international armed conflict derived from a non-international armed conflict where one international state party provided support to a non-international body. However, in the present case, Article 82E15 applies to non-international armed conflicts, and we have no reason to press that there was an international armed conflict, and therefore we do not make that submission, Your Honour. We note that our learned friends, in their written memo, refer to a lack of direct evidence as to Real Isdale having a command structure. Although we accept that there is no evident command structure on the present facts, we submit that without such command, the aforementioned capabilities of Real Isdale would not have been possible, those particularly being its ability to carry out sustained military operations against the rare earth mining sites, and so it may reasonably be inferred to have had said command structure. Further, our learned friends rely on Real Isdale's lack of territorial control. We submit that as per Bemba in the trial chamber at paragraph 134, the Rome Statute does not include such a requirement. This statement is supported by references to the cases of Lubanga in the trial chamber and Katunga also in the trial chamber. Therefore, due to both the intensity of the conflict and the organisation of the forces, we submit that it would be proper for this chamber to characterise the situation as a non-international armed conflict. Having established jurisdiction, I turn now to my second submission, found in paragraph 22 of our written memo, which is that the soldiers of the Summer Sons Brigade committed the war crime of employing expanding bullets in contravention of the Rome Statute. If I could take Your Honours to tab 3 of our bundle of authorities, which I believe you are currently at, there you will see the elements of crime under the Rome Statute. Article 82E15 of the elements outlines the 5 necessary elements for a finding on this particular crime in relation to a NIAC, and I rely on these elements for this section of my submissions. We submit that there are substantial grounds to believe that all 5 of these elements have been met in the present case. In regards to the first and second elements, we submit that the Summer Sons employed bullets which expand easily in the human body. We accept that on its own, these expanding bullets, simply being a part of the Summer Sons inventory, is not necessarily conclusive that the bullets were actually used, but on top of this evidence, the large entry and exit wounds caused to those injured in the conflict, as evidenced in the medical report at paragraph 26 of the facts.
Isn't there an evidentiary issue here? You have just used the phrase the medical report, and your written submissions also refer to the medical report, but it's a medical report cited in a local newspaper. What's the relevance of the intervention of the newspaper in the information?
Your Honour, we submit that there was no intervention of the newspaper on the present facts. And
so we believe everything we read in the newspaper?
Not necessarily, Your Honour. However, we have no reason to disbelieve the injuries that occurred in this case.
As reported in the newspaper?
As reported in the newspaper, yes, Your Honour. And we note that at this point in time, all that is required for the prosecution is to prove substantial grounds for believing the charges, not to exclude all other hypotheses beyond a reasonable doubt.
Can I also ask where you're drawing evidence from that large entry and exit wounds reflect injuries consistent with the use of those weapons, those bullets?
Yes, Your Honour. So we note that there has not been any case law on this particular area. However, in the Trifterer commentary, Trifterer describes the nature of the effect of these bullets, which is that they cause extensive damage upon making contact with soft tissue by virtue of their expanding nature, as when they hit the soft tissue, the hollow point of the bullet expands and flattens into a disc, and that disc presses itself into the human body, creating a larger entry wound and exit wound on the other side.
Are they the only bullets that create larger entry and exit wounds?
They are the only bullets in relevance to the present facts which we submit would have the ability to do that. The only other bullets that were used in this conflict, as far as we know, is the 7.62mm full metal jacket bullet, which we submit would not cause these large wounds, but would simply pass cleanly through the human body, putting a person hors de combat, but not resulting in any particularly large or aggravated wound, as to the fact that that nature of bullet does not flatten, but rather passes straight through. Your Honours, we note that our learned friends in their memo, at Indictment 2, paragraph 1, suggest that the injuries mentioned in this report could have equally been sustained by the soldiers of the Summer Sons Brigade and not by the Royal Isdale forces. With respect, the evidence does not tend towards that conclusion, as the vast majority of the casualties were the Royal Isdale soldiers. Additionally, we know that the prosecution is not required at this stage of proceedings to exclude all other hypotheses, but rather, as by Lubanga at the confirmation of charges proceedings, paragraph 39, the prosecution is simply required to provide a concrete and tangible line of reasoning for one hypothesis. In any event, we have no evidence to suggest that Royal Isdale actually had such a unique type of ammunition in their inventory at all. Therefore, we submit there are substantial grounds to believe that these bullets were employed by the Summer Sons Brigade, thus satisfying the first two elements. Turning now to the third element, we submit that the Summer Sons were aware the bullets would uselessly aggravate the suffering of those injured by them. As previously explained, expanding bullets cause larger than ordinary wounds and extensive tissue damage, which are evidenced in the facts in that medical report. This aggravated suffering is useless, as the bullets are only required to put a person hors de combat or out of action, and ordinary 7.62 full metal jacket bullets can do this without causing any additional suffering. Expanding bullets are criminalised for this reason, as was first stated in the St. Petersburg Declaration of 1868, which prohibited the employment of arms which cause superfluous injury. This reasoning is now supported by ICRC customary IHL rules 70 and 77, which are derived from many international treaties and state practices, including Article 23E of the Hague Regulations of 1899 and 1907, Article 1 of the 1980 Convention on Certain Conventional Weapons, and state practices including Australia's Laws of Armed Conflict and Germany's Soldiers' Manual. Our learned friends suggest in their memo at paragraph 2 of Indictment 2 that these expanding bullets were used for the purpose of protecting civilians. Our submissions on this purported use are twofold. First, and most importantly, there is no evidence there were any civilians near the conflict. Paragraph 25 of the facts provides a breakdown of who was killed or captured in that conflict, but it makes no mention of civilian injuries, let alone deaths. Additionally, given the shelling from both sides and chaos of the conflict, it is highly likely that if civilians were in fact present, they would have been injured. Second, at no point has IHL ever authorised reducing the potential risk of collateral damage at the cost of inflicting more serious injuries to combatants. Rather, the prohibition against superfluous injury contained in ICRC Rule 70, as previously submitted, should continue to apply. Although our learned friends state in their memo at paragraph 4 of Indictment 2 that there is nothing on the facts to indicate that the Summer Sons Brigade were actually aware of the nature of the bullets, we submit that as a result of their military training with these specific bullets, the Summer Sons must have been aware of the nature of the injuries caused by the bullets so that they would be able to employ them effectively in combat. As by the Trifterer commentary at paragraph 605, the soldiers simply need to be aware that the bullets cause particularly grave injuries. Therefore, we submit that the third element has been made out. Turning to the fourth element, I rely on my previous submissions as to the existence of a NIAC and submit that these bullets were used I submit that the employment of these bullets was directly associated with that NIAC and therefore satisfies this nexus requirement.
Could you provide a bit more detail on why you think the nexus to the conflict has been established here, both in relation to it being associated with and in the context of?
Yes, Your Honour. So it is our submission that this NIAC involves the battle between the Realisdale forces and the Summer Sons Brigade, and that the Summer Sons Brigade employed these bullets directly against the Realisdale forces in this conflict, thereby satisfying the nexus requirement.
That would satisfy in the context of, because there's an existence of an armed conflict, but in association with, can you please explain to us how the particular act, this conduct, could only have occurred in the context of an armed conflict?
Well, yes, Your Honour. The bullets were employed for the purpose of defeating the Realisdale forces, who were the other party to that conflict, and therefore were used directly in association with that armed conflict. So turning now to the fifth and final element, we submit that the Summer Sons were aware of the factual circumstances that established the armed conflict. Their purpose in Isdale was to re-secure the area, as by paragraph 24, and they were drawn exclusively from soldiers born in Isdale, as by paragraph 23. As such, they would be more acutely aware of the relevant factual circumstances due to their personal connection with the region. Additionally, we note that our learned friends rely in their writtens that the Summer Sons believed there was no armed conflict, as their commander told them it was simply a protest. Respectfully, this is an incorrect application of the objective test. The soldiers are not required to know that there was actually a NIAC at the time, but rather they must simply be aware of the factual circumstances establishing that armed conflict, as we have previously submitted they must have been. Therefore, there are substantial grounds to believe that all 5 elements of the war crime have been satisfied by the Summer Sons Brigade. Having established that the crime itself has been made out, I turn now to my third and final submission, found at paragraph 33 of our written memo, which is that Brigadier Elmes should incur command responsibility for this war crime pursuant to Article 28A of the statute, and so this chamber should commit him to trial. If I could take your honours to tab 5 of our bundle, the necessary elements for a finding of command responsibility have been clarified extensively in the matter of Denver found at this tab. And I rely on the 5 factors laid out at paragraph 407 of that matter for the remainder of these submissions. Now, Your Honours, I note that my time is due to expire in 1 minute. May I request a 2-minute extension to conclude these submissions?
Yes.
Thank you, Your Honour. Turning now to the first element found at paragraph 407 of Denver, Brigadier Elmes was the formally appointed commander of the Summer Sons Brigade, as evidenced at paragraph 23 of the facts, and thereby falls into the classification of a military commander. He also had effective control over the Summer Sons, evidenced by his official position and ability to issue orders and authorise rules of engagement, as evidenced at paragraph 24. Therefore, the first 2 elements of command responsibility, as per Denver, have been satisfied. Turning now to the knowledge element, could I please take your honours to paragraph 432 of that Denver case? At this paragraph 432, it states that the should have known standard requires the superior to have merely been negligent in failing to acquire knowledge of his subordinate's illegal conduct. Further consideration is given here to the Blaskich case, where it is stated that ignorance is not a defence where the absence of knowledge is a result of negligence in the discharge of his duties. These duties, as per Denver, include an active duty on the part of the superior to take the necessary measures to secure knowledge of the conduct of his troops, as well as a duty to secure reports that military actions are carried out in accordance with international law.
Given that Brigadier Elmes said, let's shut this down quickly, this is more of a protest, and the facts establish that the suppression was swift. When did this duty arise? How frequently was he to secure this information?
Your Honour, specifically before the conflict, Brigadier Elmes had a duty to know the nature of the ammunition of his armed forces and to ensure that it was not illegal in the conflict that they were about to go into.
But your submission has been about securing knowledge and getting reports. When was he to do that?
Your Honour, it is our submission that he had to secure knowledge of the nature of the ammunition that was to be used by his forces in that conflict before the initiation of that conflict.
And not at any time during. He didn't have a duty to secure any reports of what was going on during the time.
It's our submission that he did, Your Honour. However, our submission does not rely on that, as the knowledge requirement before the conflict is even stronger. And I turn now to whether Brigadier Elmes took all necessary and reasonable measures to prevent or repress the crimes commission. It should be noted that a breach of any one of these duties is sufficient to establish a crime, regardless of whether the other duties were met, as per Bamber paragraph 436. And Brigadier Elmes breached these duties, as I previously identified, by failing to identify which ammunition types were authorised for use, which was a very reasonable and necessary measure to take. Additionally, this failure to exercise proper control. Thank you, Your Honour.
Ms. Elmes.
May it please the Court, Your Excellencies. On the case presented today, the disputed matters far outweigh the agreed ones. I will be addressing the matters pertaining to Indictment 1 against Dr. Lee Tower for 20 minutes before handing over to my junior counsel, who will speak for a further 20 minutes on Indictment 2. We concur that on the 8th of December 2018, there was a cyber virus infiltrating the NUDF IT systems, and that there was the unfortunate and unexpected 125 civilian deaths leading from the inability of the humanitarian mission to carry out their duty. However, these circumstances are not enough to bring the charge against the defendant, Dr. Lee Tower, as the prosecution has put forth. The crucial issues contested and so far insufficiently established by our learned friends is firstly, who this operation was launched by, alternatively, whether this operation even constituted an attack, and whether the object in question indeed had protected status. The charge the prosecution has wrongfully suggested to the court today is the individual responsibility laid out in Article 25(3)(b) of the Rome Statute for the commission of the war crime in Article 8(2)(b)(3). Your Excellencies, the prosecution have not satisfied the standard of proof, that is, to provide substantial grounds to believe that the charge was committed. Today, the Counsel for Defence will show that these charges should be dismissed and not proceed to trial through the discussion of 3 points. Firstly, that the court does not have jurisdiction in these matters. Secondly, that there are no substantial grounds to contend the war crime was in fact committed by the Federation. And in any event, it cannot be established to this standard of proof that the defendant, Dr. Lee Tower, is responsible for the commission. We note that to have these charges dismissed, the defence need only prove one element of crime is not sufficiently made out to have the charge dismissed. Your Excellencies, just to confirm, my submissions on jurisdiction will pertain purely to count 1 before I hand over to my learned junior co-counsel for jurisdiction on count 2. So the defence's first submission that the court does not have jurisdiction over this matter is for the reason that there was no international armed conflict between the Federation and New Utopia. We would agree with the definition of international armed conflict put forth by our learned friends for the prosecution, beg my pardon, in citing Common Article 2 for the Geneva Conventions. This stated that in all cases of declared war or of any other armed conflict which may arise between 2 or more high contracting parties. It is our submission that, in fact, neither of these triggers occurred on the facts. Our learned friends for the prosecution have relied upon Article 14 of the agreed facts to suggest a declaration of war. However, we would submit that this court should not place much weight on this interview for multiple reasons. Firstly, we would disagree with the prosecution's submission that the speech was formal. This was an early doorstep interview, which was in fact later clarified by a press release, which instead identifies the fight against terrorism and not New Utopia. Further, declarations of war have become largely an outdated practice, the last of which was made in 1939 at the commencement of World War II by the British and the French against Germany. The British President at this time, Neville Chamberlain, who announced this to the public, we would submit that this provides a questioning as to the applicability of a declaration of war as customary in today's age. Further, we would submit that
what's the effect of that submission, that there is no such thing as a declaration of war anymore?
Not at all, Your Excellency. We would just submit that less weight is to be given to this, as essentially there are a set of formal requirements set out in the Hague Conventions that this has not applied with, and therefore, as they have become largely outdated, it is questionable whether they are still customary. Further, we would
Can I also check with you, it's my understanding that the prosecution relied on paragraph 7 of the facts, not paragraph 14. No one did.
My apologies, I believe that was my mistake. I would refer to paragraph 7.
So could you explain why that, at paragraph 7, that's not a declaration?
Apologies, I do retract that statement. I would rely on 14, where the President in a press release does actually say that in an early unscripted morning doorstep interview that we are at war, and we would submit that this is the correct paragraph to be submitted.
So you're saying that what the President said later at paragraph 14 clarifies what is relied upon in paragraph 7?
Paragraph 7 we would not submit is a declaration of war. We would submit that this is much better attributed to paragraph 14, and the clarification was made in a later press release stating that the President is pleased to provide robust support to the police of Israel to provide for community safety by eliminating terrorism. Further, we would submit that there are not substantial grounds to find the existence of an armed conflict between the two states, as it cannot be said with confidence that the cyber operation launched on the 8th of December 2018 was done so by the Federation. It is correct that paragraph 21 of the agreed facts implements the Federation with evidence that the virus was delivered from an IP address previously associated with the Overseas Intelligence Agency, and we would wish to draw attention to this word previously in regards to this raising further doubt as to the attribution of the virus. Further, with regards to the same evidence relied upon by the prosecution, it is the defence's submission that the possibility of a spoofing attack where hackers impersonate organisations or their IP addresses to carry out such operations is no less likely than what the prosecution has put forward. In fact, a particular case is where the NATO Cooperative Cyber Defence Centre of Excellence were impersonated by hackers to infiltrate the Ukrainian government systems. The second piece of evidence the prosecution has relied upon is where President Tower was recorded referring to a piece of code from the virus. And we would submit that this cannot be deemed a reliable piece of evidence, as it tells us nothing to the context of this reference or in fact the conclusion of the meeting. In the event that the court does find sufficient evidence to support the existence of an international armed conflict, I will now turn to address our submissions that the war crime suggested in Indictment 1 cannot be established on substantial grounds.
Before we do that, can I just ask if you have any examples of state practice that would support your argument that there's not sufficient evidence that the cyber attack came from the Federation?
Your Excellency, we do not have any state practice. We would rely on the facts here in that it is merely circumstantial, and on the fact there are in fact 3 states that all would have the capabilities to commit such an operation. Turning to...
Is there any state practice that would look to emerging custom around when states will accept another state holds responsibility?
So in terms of state attribution, we would refer to Article 91 of AP1, where a state is responsible for violations of international humanitarian law attributable to it, where the violation is committed by its organs, including its armed forces. And we would submit that this here is the applicable situation in this case, but however we would suggest it is not made out. In regards to Indictment 1, the Federation have come under unreasonable scrutiny as the suspect in the launch of the military cyber operation. It is our submission that the elements for crime under Article 82B3 cannot be made out to the standard of proof required by the prosecution. The elements in contention that I will step through in our submissions are as follows. Firstly, that there is not sufficient evidence to regard the cyber virus as an attack against humanitarian missions. Secondly, that the evidence is not conclusive or persuasive as to the protected status of the object in question. And finally, that the mens rea of the crime cannot be sufficiently established. With regards to our first submission that there is no attack, we concur with our learned friend's referral to Additional Protocol 1 in the definition of attack as an act of violence against the adversary. And we would further agree that it is possible that violence can be determined by its consequences. Yes, it is true that cyber operations do not necessarily utilise the same kinetic methods or violence as traditional attacks. Thus, a threshold is needed to determine whether a cyber operation is in fact an attack. We would refer to the Tallinn Manual in this case at Rule 92, which provides the definition of a cyber attack as a cyber operation, whether in offence or defence, that is reasonably expected to cause injury or death to persons or damage or destruction to objects. And it's the defence's submission that this threshold was not met. The target of this cyber operation was the NUDF IT systems, and whilst we submit there are more grounds to argue an attack against this particular system, it cannot be said that the impact on the humanitarian software One Logistics was reasonably expected or foreseeable.
What are the facts that you use to make that submission about reasonable foreseeability?
Yes, we would submit that it could not have been reasonably expected because it is unreasonable to presume that the Federation was aware of this connection between the two softwares. For example, the statement given by the community NGO representative praising the NUDF IT infrastructure was only taken by a local radio station, and it's the defence's submission that there is nothing to suggest that the Federation was aware of this broadcast or in fact that it reached international borders. And further, at paragraph 20, we are told that this One Logistics software is only recently rolled out. So we would submit that the Federation would not have been aware of this. Further, in paragraph 20...
Would you expect, that a state would have that kind of information in carrying out such a sophisticated attack, that they would know the expected impact of it? Would it include a civilian object?
We would submit that they did not know and could not have been aware that there was this connection. We would also refer to the surprise of the task force representative at paragraph 20 when they are asked how it was possible that the civilian software was also impacted. For if New Utopia could not have anticipated that a cyber operation would affect civilian software, then it could not be reasonable to presume that another state could have. And for these reasons, we would conclude that there is insufficient evidence on the facts to infer the characterisation of the cyber operation as an attack, thus failing the first element of the crime. Your Excellencies, we would further submit that the evidence is insufficient to conclude that the civilian software indeed had protected status. According to Article 19 of the 4th Geneva Convention, civilian and humanitarian objects will lose their protected status as soon as they engage in conduct harmful to the adversary. Although the facts imply that One Logistics was purely for civilian use, it was reliant on the NUDF IT systems and thus would be characterised as a dual-use object.
So just to clarify, it was an attack against a dual-use object? And what was the military advantage of that attack?
We would submit that in terms of protected status and being a dual-use object, this then comes under proportionality, which then states that the parties to the conflict should evaluate expected casualties or impact to result from an anticipated attack and ensure this estimate is not excessive in relation to the foreseeable military objective. And we would suggest that the military advantage here is the acquisition of new utopian data and intelligence, as well as hindering their IT systems in order to investigate future new utopian interference with politics in the Federation. The trial case of Galich explained that there is no mathematical formula to determine what number of casualties or what extent of damage is reasonable. But the court does go further at paragraph 58 to say that whether or not this duty has been fulfilled is to be assessed with regard to whether a reasonably well-informed person in those same circumstances could have expected the attack to result in disproportionate damage. And we would submit on the evidence available that a reasonable person in these circumstances cannot have been said to have anticipated a cyber operation to result in any disproportionate damage. The damage intended in this case, as we have discussed, was the delay of new utopian Defence Force IT systems. A reasonable person with the same knowledge at their disposal would not have been aware of the connection between the two systems, and thus the only anticipated or expected effects were that of the NUDF. Moving to the defence's next submission, the evidence is not sufficient to establish the mens rea of the crime. The prosecution has relied on the trial case of Katanga to establish the required knowledge as intent to target the object. However, the defence submits that there is no sufficient evidence on the facts to say that the accused perpetrators had this direct intent to target the object. The medical data was not the primary object of attack, as has been suggested, and that the intention cannot be simply inferred by looking at the nature of the attack. Referring again to paragraph 20, the repercussions on the humanitarian mission was unexpected, and to simply use the statement that the virus was sophisticated when we are not informed as to what this sophistication entails would be unreasonable. Your Excellency, we would submit now that the elements of crime cannot be sufficiently made out to establish the commission of the crime by the Federation, as any inference on the facts to this end would cause injustice.
I'd just like to take us back to a previous point that you made around the status of the humanitarian mission. Are you saying that the object is of mixed use, or are you saying that the humanitarian and civilian objects actually became in and of themselves military objectives because they were using this software?
We would suggest that it was a dual-use object because it is not possible for civilian and military status to exist within the same entity. And we would refer to Rule 101 of the Thailand Manual to further expand on this, which uses the analogy of roads. It states that as long as it is reasonably likely that civilians and military objectives travel the same roads, then these roads become lawful targets for military operations. But again, this was subject to the principle of proportionality, which was not breached.
Okay, but you're not saying that the humanitarian objects have actually lost their protective status because they've engaged in conduct harmful to the enemy?
We would suggest that by becoming a dual-use object, they have lost their protected status.
Right.
Now turning to the next substantive part of our submissions concerning the liability of Dr. Lee Tower. The prosecution has contended Dr. Lee Tower ordered the supposed cyber operation in question and brought the charge under Article 25(3)(b) of the Rome Statute. However, they have failed to prove all elements of liability to the requisite standard of proof. We would agree with the elements put forth by the prosecution that are needed to be established in order to show ordering, and this was that the defendant was in a position of authority, that they gave an order, and that they had the intent or were aware of the substantial likelihood of the war crime being commissioned as a result of the order. The defence admits that the evidence is not sufficient to support all of these elements. It cannot be disputed that Dr. Lee Tower was in a position of authority as the President of the Federation. However, he gave no such order to his subordinates to commission the crime at hand. In the trial case of the prosecutor and Blaskich, this tells us that this order may be explicit or implied from the facts, and it is our submission that the facts are neither explicit nor implicit as to him giving this order. As the defence has already submitted in regards to attribution when discussing jurisdiction, the film obtained by New Utopia at paragraph 21 of the facts provides no context as to the meeting and therefore is not substantial or convincing enough to implicate Tower. Thus, we would submit that this actus reus is not sufficiently made out. Your Excellencies, I note that I only have 1 minute remaining. May I request a further minute to conclude?
Yes.
In any event, Tower did not possess the requisite direct intent or awareness of the substantial likelihood, as discussed in the appeals case of Cordich, that the alleged war crime would result from this purported order. There is nothing on the facts to suggest that he was aware that the civilian software was connected to the NUDF IT systems or that there was a motive to cause detriment to the humanitarian missions. Your Excellencies, the defence has submitted that the evidence provided by the prosecution cannot be considered substantial enough to implicate the Federation, and further, Dr. Lee Tower by way of ordering the commission of the crime under Article 82B3. We would respectfully request that the charges be disregarded and proceed no further in trial. May it please the Court.
Thank you very much, Ms. Elmes.
There's substantial grounds to believe that the perpetrator, being the Summer Sons under Brigadier Zilos's command, have breached Article 82B, Roman numeral 19 of the Rome Statute, nor in a time of non-international armed conflict, 82E, Roman numeral 15 of the Rome Statute. Now, these articles govern the prohibition of utilising expanding bullets in times of armed conflict. And we intend to show that this has not occurred. Contrary to what the prosecution has put forth for you, this case actually concerns the internal suppression by the state of the Federation to threats of terrorism within its land. Now, the Federation engaged troops to assist in domestic law enforcement and thereafter successfully managed to suppress the threat presented by Real Isdal. The Federation's actions were a necessary measure to restore order at Isdal and ensure the safety of its civilians. Now, as discussed by my learned senior counsel, we would firstly submit that there are insufficient grounds to establish an international armed conflict occurred. I will address Your Excellencies on this issue firstly. However, we would also raise an alternative jurisdictional argument and rebut the prosecution's submission that a non-international armed conflict occurred. Turning firstly to the possibility of an international armed conflict, the prosecution have contended that as the conflict involved New Utopian Defence Force soldiers, this meets the requisite armed force between high contracting states. However, we have no indication that the New Utopian Defence Force actually engaged in any armed violence. Whilst we can acknowledge that members of Real Isdal were killed during the time of unrest, it was entirely in the midst of restoring this order to Isdal. It doesn't indicate that New Utopia was involved. In fact, on the evidence, we see that Federation members and New Utopian Defence Force members Real Isdal members incurred casualties. However, no New Utopian Defence Force members were killed during the conflict. What's more, the original statement made by Leader Hay committing to deploying 2,500 troops is absolutely inconsistent with the mere 20 New Utopian soldiers found on the Federation soil.
Is the amount of casualties from a particular group reflective of whether or not they can be considered a party to the conflict or be providing sufficient material support to an armed group?
Your Excellency, in this case, we are looking to the existence of them engaging in the hostilities. Now, if we look to the two primary parties, the Federation and Real Isdal, who both incurred casualties during the circumstances, it is unreasonable to infer that New Utopian Defence Force soldiers were involved if we cannot see, A, that they were there and engaging in the hostilities, B, that they actually did sustain any casualties. So this is just speaking to the evidentiary point that they were not likely engaged in armed violence.
But do you agree that a party to the conflict can have overall control from a distance?
Your Excellency, with regards to overall control, this requires something more than the mere equipping and financing of weapons, as was held in Tadic, and it does require this further planning and operational support. And here we submit this hasn't occurred. We can see that they potentially provided weapons to occupy Isdal, which isn't necessarily associated with the real Isdal. But we do see no evidence that they engaged in operational planning with real Isdal. And this is supported by the fact that real Isdal do have their own political beliefs that they are trying to pursue with this, that are not necessarily affiliated with New Utopia. However, the prosecution submission that they have primarily put forth for this charge is with regards to a non-international armed conflict. So if it pleases Your Excellencies, I will address this in further detail. Now, turning to a non-international armed conflict, our submission is that the incidents were in fact civil unrest. Now, President Tower, I quote, states that he is providing support to the police of Isdal to provide for community safety by eliminating terrorism. And equally again, Brigadier Zilas told his own troops, this is nothing more than a protest and we don't want to start a war. It should be considered by this court that the Tadic trial judgment asserted an armed conflict must be distinguished from banditry, unorganised and short-lived insurrections, or terroristic activities which are not subject to international humanitarian law. The Rome Statute of this International Criminal Court specifically outlines at Article 8, subsection 2FE, that it does not apply to such internal disturbances. So, whilst the Summer Sons military forces were utilised, this does not mean that there was an non-international armed conflict. It was in fact entirely appropriate, and what we can see is that the group Real Isdal had presented a threat to fighting them, and that the local state government of Isdal requested military assistance to counter this threat of terrorism.
So how do you explain the high number of fatalities in arguing that the sporadic acts of violence weren't intense enough to satisfy the threshold of NIA? And on the issue of employing forces, then how do you explain not just relying on police forces if it was just an internal civil matter?
Yes, Your Excellency. Turning firstly to intensity, we would note that there is no one singular test that this court considered to meet the requisite intensity, and that simply because a certain number of casualties were sustained, this doesn't mean that it reached the actual threshold for protracted armed violence, which is what is required under Tadic. Now, we can see that in fact Real Isdal was suppressed within a single night on the facts. So whilst perhaps 279 members were killed, this was a swift suppression that was achieved pursuant to the thousands of members that were presenting a threat. And this is not necessarily intense, it was rather effective in the circumstances. And turning secondly, would Your Excellency mind repeating the section?
Sure, it's about the kind of forces that were employed for this operation.
Yes, Your Excellency. So we would submit that as the domestic legislation of the Federation provided an option for the local state government to deploy military forces to assist them, that this doesn't render the conflict non-international. Rather, it actually goes to show that this was well within their sovereign right to domestically enforce troops to counter the terrorism threat. So, whilst military troops are a factor that must be taken into account in showing this requisite intensity, it's not conclusive, and we would submit that rather it actually goes to show that this was this civil unrest and that the Federation was countering it within their own territory. Turning perhaps to organisation as well, which is also required for the prosecution to make out. They've stated that Real Isdal's access to weaponry, for example, is a contentious factor in determining that they were organised. However, in the Harder-Nudge trial judgment, they stated that the existence of a command structure and disciplinary rules and mechanisms within the group, and that the group controls this certain territory, its ability to plan and coordinate military operations are all factors to take into account. So whilst the prosecution has submitted that they must have been able to have this command structure as they evidently engaged in these operations, we can see they were suppressed within a single night against an organised armed group. This would give sufficient evidence to this court that they were in fact not able to effectively plan and coordinate these military operations with any level of sophistication other than the fact that this was a sporadic act of terrorism on this singular night.
Why is that not equally consistent with the idea that they were simply outgunned?
Pardon, Your Excellency?
Why is that submission not equally consistent with the fact that they were simply outgunned?
Your Excellency, we would submit that there were thousands of realist ALSA members on the facts, and that if they had this requisite level of organisation, this would have likely resulted in a different outcome.
Even though they didn't have the same kind of weapons as the other side?
Your Excellency, the facts show that they in fact had military-grade equipment. The facts are not more specific as to the certain types of equipment. However, as it is of this military grade, they could have equally had the same weaponry that the Federation had. Perhaps turning to the alternative that the defence would put forth before you, which is that if you do find there was an international or non-international armed conflict, that in any case the relevant elements of crime are not established. Now, to summarise 3 contentious elements before the court today, these are that the perpetrator employed expanding bullets, that their use was such that it actually violated the law of armed conflict, and thirdly, that the perpetrator was aware that the nature of the bullets was such that it would uselessly aggravate the suffering effect. Now, speaking to the first element, there is no explicit evidence to establish substantial grounds that the perpetrator, the Summer Sons, used expanding bullets. Whilst we can acknowledge what was put forth by the prosecution, that these bullets were in their inventory, this alone is not sufficient to actually show attribution to the Summer Sons as the force. Regarding the injuries incurred, we have no evidence as to which parties actually sustained these, and these could have plausibly been sustained by Summer Sons members themselves. What's more, we see that there are fragmentation grenades, intermittent crossfire and shelling from both sides, which could both similarly cause these types of injuries. So, if the court finds that expanding bullets were utilised, our primary submission is that there is insufficient evidence to show that it was real Israel who utilised these bullets.
Given that you argue that real Israel doesn't have sufficient organisation to meet the requirement of an organised armed group for NIA, how do you explain why they would have this kind of sophisticated weaponry?
Your Excellency, we would submit that the type of weaponry speaks less to organisation and more to their ability to gain access to weapons. And on the facts, the specific outline that it's military-grade equipment would equally be possible to show that it could be sophisticated weaponry, even if they are not able to utilise it in an organised manner. And in any cases of doubt, as the defence, we would like to remind you that to construe such ambiguity in this case against the defendant would be unjust. And it is Article 22, subsection 2 of this court's international Rome statute that says the definition of a crime shall be strictly construed and not extended by analogy. In cases of ambiguity, the definition shall be interpreted in favour of the person being prosecuted, investigated, or convicted. Alternatively, we would turn to the bullets' violation of the law of armed conflict if Your Excellencies find that they were utilised by the Summer Sons. Now, under this second element, our submission is that if expanding bullets were used, it was only in the time of domestic law enforcement. So it is important for us to reiterate that in cases of non-international armed conflict and the law of armed conflict with the domestic law enforcement, they must actually act in parallel of each other. So a conflict can have these internal characteristics whilst a state is actually having to suppress domestic threats within it. And it is with this regard that we would submit any usage was under the domestic rules of engagement which were authorised by Brigadier Zillos.
So it's not because it's a law enforcement situation per se, but a NIAC where law enforcement rules apply? Is that what you're arguing?
Your Excellencies, as the elements of crime are only applicable in the alternative that the court finds there's an armed conflict, we would submit that in any event they would be utilised in the domestic law enforcement circumstances within this NIAC. And speaking to this, it was Rule 77 which the prosecution have spoke to of the international criminal, of the international customary law study that was conducted that actually spoke to this and really discussed the complexity of the issue before the court today. And they said that several states have recognised that for domestic law enforcement purposes, it may be necessary to confront an armed group in an environment or crowd of people in where such a case the bullets may be necessary to ensure that they do not pass through the body of other people and into the civilians nearby. And we would submit this as analogous to the present scenario in the case that President Tower engaged these summer sons with the direct intent of clearing protest areas. Now,
is there sufficient state practice to show that they agree with this ICRC interpretation of customary international law? Because it is ultimately up to states to act in a way that creates custom, not the ICRC to determine that several states have decided that this is customary.
Yes, Your Excellency. So it is customary international law that these are prohibited in times of armed conflict, and the defence does not contest this. However, for example, the United States have specifically objected to this and ensured that they recognise that when it is for domestic law enforcement, these expanded bullets may be necessary to, in fact, reduce the superfluous injury to civilians nearby in the conflict. And we would submit that this, as well as the other states who have spoken to domestic enforcement and implemented it in their domestic legislation, do demonstrate state practice to this specific issue which was discussed by the International Committee of the Red Cross. And we do acknowledge that this is a difficult issue for this court, but the Tadich Appeals Chamber recognised the dividing line between these areas of internal conflict and law enforcement is not always going to be clear. And if the reduction of risk to innocent civilians nearby is a factor relevant to looking to superfluous injury and unnecessary suffering, then it would be warranted to conclude that these potential victims of a terror attack, by utilising the expanding bullets, are actually being benefited, and it reduces the suffering in the exact same sense.
And is there anything in the facts that would indicate that that is why the bullets were used?
Yes, Your Excellency. Firstly, we would look to the fact that the Summer Sons were employed after the request of ISDAL for its civilians to assist their safety. And secondly, by Brigadier Zillos, who commanded his troops, that this was to clear protest areas and suppress them swiftly and quickly in the defence of public safety, it was quoted in the facts. So yes, we would say that this is sufficient evidence to show it was in fact for the civilians of ISDAL as to why these were employed. Turning finally to the mens rea of the offence, we would perhaps talk to the prosecution submission regarding the factual circumstances and the nexus of the armed conflict. And here we see multiple statements made by all involved that this was not an armed conflict. And whilst we can acknowledge pursuant to Cordage that the correct legal evaluation of the armed conflict isn't necessary, they were evidently not aware of factual circumstances which established an armed conflict in this circumstance. And it is for these reasons that we submit that the perpetrator did not breach Article 82b19 of the Rome Statute. However, if the court does find to the contrary, we would also submit Brigadier Zillos should not be held individually criminally responsible. We would concur with the prosecution that Brigadier Zillos was a de jure military commander in the circumstance, and this is governed under Article 28A of the Rome Statute. Your Excellencies, might I request a further 2 minutes to address you on command responsibility?
Yes.
So there are two specific things which must be established by the prosecution under this. And these are firstly that Brigadier Zielos knew or should have known that the troops would be commissioning the crime, and secondly that he did not prevent their conduct. Turning to knowledge first. On the facts, we do not have sufficient evidence to show that he could have actually known that they would utilise them outside this domestic enforcement circumstance. The rules of engagement were under the domestic legislation. He specifically limited the use of lethal force and stated it was only to be in this defence of public safety or in self-defence. And this would all go to show that the authorisation of expanding bullets was only to be in the domestic enforcement as opposed to an armed conflict.
Considering the rules of engagement are classified, how do you know that they're just based on domestic law enforcement?
Your Excellencies, in the facts at (14), it was stated that the Summer Sons were deployed under the Federation legislation. So we would submit that as they were deployed in accordance with the Federation legislation, that the rules of engagement were also under this domestic legislation. And further, as the rules of engagement speak to only using lethal force in defence of public safety and self-defence, this would also go to show this domestic aspect to it. It is the bedrock of domestic enforcement that limits the use of lethal force to these circumstances only when absolutely necessary. Turning finally to his necessary and reasonable measures, we would submit he did in fact take these, and the Mukic trial judgment reiterates it is only what is within one's material possibility in these circumstances. And contrary to what the prosecution had put forth, he limited the authorisation of force to specific circumstances, and there is nothing more he could have actually done to ensure that they didn't utilise these expanding bullets, considering that lethal force was only allowed in this domestic law enforcement situation. And international law cannot oblige a superior to perform the impossible in these circumstances. So, to summarise the requested prayers for relief, we submit there is no international or non-international armed conflict, that if expanding bullets were utilised, it was under the Federation's domestic legislation, and in any case, Brigadier Zielos is not individually responsible. For these reasons, we respectfully request the court find that there are insufficient grounds to establish the perpetrator committed the crime and that Brigadier Zielos, the second defendant, be held responsible. May it please the court.
Thank you, Ms. Chalmers. Reply, Mr. Rourke? Or Mr.
We have not reserved any time for reply.
Very well. We thank the parties. The bench will go off and consider the matter.
All rise. You may be seated. All rise.
You really don't have to anymore.
Please be seated.
Well done, everyone. You made our job very tricky, what we've just been doing out in the jury room. Of course, it's a state secret what's happened in the actual moot, but we just thought that we'd give you some general feedback about about your performances and give you an opportunity to ask us any questions if you want to. The take-home message for all of you is that well done, like really, really well done. The standard was very, very good. Advocacy, if that is where you want to go in your legal careers, is not something that you just turn up to court and do. It's something that you have to work at, and you don't just open your mouth and start talking, as all of you no doubt have realised through this exercise. And like a muscle, it will get stronger the more you use it. One thing, all of you, slow down to the point where you sound like you're being an idiot in your head. Partly I suspect it was nerves, partly is that you had so much that you wanted to say and you were rushing to get through the time. But the power of speaking slowly and speaking deliberately is never ever to be underestimated. This obviously is an artificial environment with the time constraints. The next time you will have time constraints like that will be when you're doing your first special leave application in the High Court. I can tell you that that's far more terrifying. But the amount of work that you had put in was evident. Can we ask, because we're interested, who's actually studied IHL in their degrees?
We did it as an elective at our uni, so that was last semester, just 3 course. Professor Dale Stevens is the one who taught it to us, so yes.
Because it's tricky.
It is.
We can say
This
this
was
for
my first time seeing it.
Right.
just doing international law course at the moment,
Yeah.
so I was learning all customary laws.
I've never touched something as that.
Well, you did wonderfully well with that, either not having done it or having just studied it, and as you discovered, it's quite different from domestic law. It's both its frustration and its attraction in many ways. But my sister judges, no doubt wish to provide some feedback as well.
Yeah, we won't keep you too long, but just to echo her honest statements that it was very impressive both in your presentations and your grasp of IHL, and especially this question involving cyber issues, which is an emerging and grey area of law. You all tackled that well. I think that's all I've got to say.
Yeah, I don't have much to add either, actually. I think it's been covered. Yeah. Unless any of you had any questions.
Yes, this is your opportunity.
Yeah.
So,
Put us under pressure.
you don't have to, by the way, but you can.
Do you think this case would actually have gone to trial on the amount of evidence?
Are you asking me if I'd be the judge?
If you were the judge.
If you were the judge and it
I
wasn't
wouldn't go
real.
through.
Silly prosecution.
Yeah.
Why would you do this?
But that's only on the basis of an incomplete statement of facts.
Yes.
So,
Yes.
Yeah.
So that's an answer that's very much constrained by the deliberate ambiguity
True.
in the facts as stated. And I would have asked more pointed questions about the evidence, I think.
Yes.
Anything else?
Where does your interest in international humanitarian law come from? I'm not sure as to what all of you specifically do or have done in the area.
Okay.
So my area is actually international humanitarian law, so I'm in academia. My interest in it actually grew when I was doing undergraduate law, and I did an internship overseas at a human rights organisation, and then came back to Australia and wrote an honours thesis based on that, and then I went on to PhD and so on. And I've actually really enjoyed the combination of academia and also doing more applied work, so that's a great thing about IHL. There's organisations like the RCRC, which Yvette knows more about, the UN, NGOs and governments, so there's like a range of practical work involved in it as well.
Yeah. So my interest really was a very personal one. So my grandparents have found, so I was interested in both the Red Cross as a very unique organisation in the area of IHL and IHL itself. My grandmother had started studying international law at uni in the 30s, which was pretty unusual, and then her studies got cut short and she ended up, both my grandparents were caught up in the Second World War, and my grandmother in particular woke up in a field hospital having fallen into a coma, and the first thing she saw was people running around with Red Crosses on them. And then we found some family through the Red Cross Tracing Service. So I had a very personal connection and affinity with the Red Cross in particular, but also looking at how the law can practically be used in really the worst of circumstances. And it's been a very rewarding path so far.
And I'm currently a judge of the Supreme Court of Victoria, but in a previous life, I was a barrister at the Victorian Bar, but I was the senior trial attorney at the Special Court of Sierra Leone in the early 2000s. I was the senior legal advisor to the Independent Commission of Inquiry for Timor-Leste in 2006. I was an expert of the European Union Commission of Inquiry into Kyrgyzstan in 2011. So I've dabbled professionally that way. I currently am on the Executive Committee of the International Commission of Jurists, and I'm a board member of an NGO based in Geneva called Civitas Maxima, which well, you can look at the website, I suppose, but it's very, very interesting and worth looking at. So, dealing with international crimes. So that's how we all came to be here. But it's a fascinating area. So I encourage you to continue, and good luck with the rest of your studies, and enjoy the rest of the ALSA conference, which back in the dinosaur era I once went to. So. All right, well done.
Thank you.
If there's nothing further, I would just like to thank all our judges today, especially Sarah Justice Taylor.
No, not especially.
And we have these gifts for you, and we're so thankful for you giving us the time as students in this academic. Thank you. Thank you so much.
Yes. That's all right, they're up there.
Of course.
That's fine. Is that it? Yes. Thank you.
There we go.
Maybe just come around the front.
Yeah, just round right here, guys. So we're just along this wall.
You did? It was like herding cats.
Just try and this way.
Yeah. Should we
Knee with the front.
have some
Just function a little bit. Yeah. Perfect. And 3, 2, 1. And we'll go again. And 3, 2, 1.